Coming to you from Dover, Ohio and Somerville, South Carolina. Two cities with absolutely nothing in common until now. This is Make Photography Great Again, a weekly podcast of commentary on the photographic industry. And now, here are your hosts, master photographers Christine Walsh-Newton and Ted Linsack.
So, welcome. This is the Make Photography Great Again podcast. So, right off the bat, really interesting article. This one has been making the rounds, I guess you can say, on Facebook and some other social media, and it's pretty interesting, I gotta say. So, I'm not sure if you've seen it, Christine, and I'm trying to see who actually wrote this. It's from a certain website. I have it pulled up here. The Copyright Zone. So, I don't sure if I know these guys.
Well,
Edward Greenberg and Jack Reznicki. I think I know Jack. I've heard that name before.
Jack Reznicki used to be the president of the PPA back, I would say, the early 90s. I actually went on a trip that he mentored in I don't even remember. It was in the 90s as well, but I went to Puerto Rico, and it was a photo thing, so I met him down there. Real great commercial photography in New York City, and he's been doing a lot of stuff in the copyright realm.
Awesome. Well, this apparently is his site, the Copyright Zone, and this has been on a few different forums and pages on Facebook that I saw yesterday. I think it makes a great point. So, a couple of days ago, I got my copy of the PPA magazine. So if you're part of PPA, the Professional Photographers of America, they put out their own magazine every month. The Professional Photographer, right? I probably should know what it's called. But I noticed on the cover, and I have no idea who did this photo, nor am I going to look it up. But it's a very Rockwell-esque photo, and I'm not sure if there's actually a name for this photo, a name for the original piece. But basically, it's very, very closely related or resembles a famous Rockwell painting that appeared on the Saturday Evening Post. And I didn't really think anything of it until I saw this article. And basically, this article is making the point that this piece so closely replicates this Rockwell piece that is there an issue of copyright? Does copyright come into play off someone looking at a painting and basically emulating it very, very closely? Is that a copyright issue? And I got to say, it makes some good points. I don't even really know how I feel 100% about it. I think there's some good points on both sides. Did you happen to see this article though that I'm talking about?
Oh yeah, read it yesterday actually. So totally understand.
Let me read, for those of you that maybe have not seen it. Let me read just a little bit from it, and then we can try to dissect it and see what the heck this means. So, it starts off, so how's this for irony? April is Copyright Awareness Month, according to the April issue of PPA's Professional Photographer magazine. I love that's such a great.
Pretty ironic.
You know it's going to be good when it starts like that. So it goes on. Terrific. Photographers and artists need all the awareness and information about copyright they can get. Anything that spreads awareness of the truth is always positive. But something struck us as well a bit odd. The cover of the magazine is shown along with the famous Norman Rockwell painting that graced the cover of the Saturday Evening Post in 1957. I believe they're showing both of these side by side in the article. These two images surely look similar to a lot of viewers, maybe too similar, maybe a tad too much copying. To us, it's not as much a photograph of After the Prom, which is Rockwell's title, but more of a photographer, quote, dancing with danger. And I think that's kind of the name of the article. So it goes on and on. Let me pick up here a little bit, and then we can talk about it. So the next paragraph goes on. It says, nearly all artists are influenced by other artists and, of course, by the world around them. But when, as a photographer, you copy numerous details with precision, into a... Okay, we're going to edit this, and I'm going to go back.
Okay.
And cut this out. So the next article goes on, and it says, nearly all artists are influenced by other artists and, of course, by the world around them. But when, as a photographer, you copy numerous details with precision and to a significant extent, you then may find yourself accused of copying someone else's work. Rather than creating something novel, you might be accused of creating an infringement of a registered work created by someone long ago, even before you were old enough to chew on a pencil, let alone draw with one. This is great. I mean, they're really getting into it. So there's a bit more here, but let me tell you what I think. I think it's an interesting concept, and I don't know fully how I feel about it. I think there's something valid to someone bringing up the point that, yeah, if you take a famous painting or a famous work of art and you go through and you completely duplicate everything, I mean, I think there's a point. I think it's maybe more of an ethical question to completely rip someone off, if I can use that phrase. But the thing that makes me go back on it is if we take that logic and you go backwards with it, geez, as a wedding photographer, there have been a million photographs of a bride in a window. There's been a million photographs of brides at particular spots that have roughly been similar. I mean, there are popular areas that so many people go to, and we, even without knowing, we tend to do things that are pretty similar if you put them side by side. So my question is, if this is true, if you take a famous work of art and it comes really close, what about everything else? I mean, what about the instance of the bride at the certain venue if it comes close? Is that now copyright infringement as well, or does that only apply to famous works of art, and who dictates what is famous and what is not?
I don't know that.
What do you think?
Well, and I'm sitting here thinking, you brought up the whole wedding thing, and, we see people doing that left and right. I mean, just this week you posted kind of the setup for how to do one of your really cool bride and groom on a elevated position with off-camera flash image. You basically put down the steps for us to copy if we wanted to try that same technique. But I wouldn't say that if we did that we were copying the piece that you showed us as an example of how to do it. So, nobody can copyright a pose or an idea or a general kind of thing. And I think that's where the distinction is. This particular image was replicated detail by detail by detail. You can tell it was an intentional copy. However, they start using the word derivative here, and derivatives are a little bit, you got some different rules there. I mean, like in the music industry, you can do a parody of any song that you want. As long as you have changed the lyrics and they're funny now, you can get away with cutting that song over again and not having to pay a royalty to the person that actually wrote the music. So there's this derivative stuff that's a little sketchy that I don't fully comprehend.
Well, you mentioned the off-camera flash, and honestly, I didn't come up with off-camera flash technique, and I think a lot of photographers, you talk about concepts like that. I mean, yeah, shooting with off-camera flash, or shooting with video lights, or doing 3 or 4 or 5 light studio setups. I mean, there's certain little things that, yeah, I mean, at some point, someone came up with the idea. I guess someone refined it, but man, so many people either put a little bit of their own spin on it, or they're simply, teaching that concept to someone else. And I don't think that's exactly the same thing.
No, let me talk about an example. I had somebody write me, it's been a bunch of years ago, but they were pretty upset. And they showed me this image and they said, "What do you think about this?" And I said, "I think it's a pretty image. What's your point?" And then they sent me one of theirs. And they were really, really pushing the point that this second photographer copied them. And, honestly, it was a bride going down a set of steps from above. I have seen that kind of picture done like 200 times. So, it was a public venue. It wasn't like this person built that stairway and it was all theirs. And I don't know. It's just like, I don't think that you can copyright general stuff like that, especially stuff that's done out in the public. It's just, you didn't have the control over all that stuff. So how can you say it's yours?
I think it opens up a lot of that discussion because there is so much of that. Like you mentioned, and I mentioned before, there's so many venues and different things like that where we all come very close to being in the same boat. So I guess the question is, if there is something that is more considered art, something like Norman Rockwell or famous painters, people that I guess are more known worldwide, is there a separate standard for those kinds of things? I mean, do you think that, because this whole article basically says, hey, it makes mainly the point that this is a Rockwell. I feel like if I shot something like this, or if I painted, let me say I painted something like this, and someone came to do it, no one would ever know, obviously, because no one would have ever seen my crappy painting. But since this is a Norman Rockwell, and it's considered, Americana and more well-known, do you think that that's the difference?
I would think that we were living in a sad, sad world if we only applied copyright protection to famous people.
I would agree. I think I would agree with that. But it seems like that's the gist of at least what this article is trying to say. Because
no, I don't think so. I think just the fact that this is a well-known image brought it to our attention that it was copied. What if this person copied some artist in their hometown? We would never know that they duplicated somebody in their hometown unless the hometown person made a fuss about it. And then, honestly, you're right. We probably wouldn't think that was much of a big deal because they weren't getting rich and famous off the original. You know, the injury to the defendant would be slight.
Yeah. No, I see that. It's, and the article goes, let me read from it a little bit more because I think it makes a little bit of a better point here as it goes on. So basically it says, theoretically, one is not permitted to register a copyright of a copy of another's work, as it's not an original expression. In this case, a comparison of the two images by a jury could yield a determination that the photo is actually an unauthorized derivative of the Rockwell painting. An unauthorized derivative work can be an infringing work. Different judges and juries could easily come to different conclusions. Looking at these images as a jury would conjures the phrase too close to call. Neither of us would be the rent on the outcome of a jury's view as to whether this photo is a copy of the Rockwell illustration. But then, we also wouldn't bet on a jury's outcome in any case that has two sides, no matter how obvious the outcome appears at first blush. I just think, as far as I know, and I'm not a copyright law expert, but I've basically always understood it as, basically as soon as you take a frame or you click that image, for a photographer speaking, I should say, you own that copyright regardless of, you can't copyright the concept of an idea. That's how I've always understood it. And this, to me, it'd be one thing if it was even if it was a photo, though. I mean, even if someone took a photo of that scene and someone duplicated that scene and they were both photographs, I still think, even if you've totally copied it piece by piece, it's still, to me, I almost view it as it still kind of is your original creation in the sense that you did set everything up and you shot it. Obviously, you've copied the details, but I don't know how that would go, if that would actually go to court. I'm curious as how that would pan out in a courtroom setting or in a litigation setting.
And I'm a little confused since they are referring to an image on the copy of PPA magazine. I'm assuming that was from the loan collection. So I don't know if the jury that they're talking about is a competition jury or if it's a legal jury, because it looks to me like the outcome of the article is that this is not a copyright infringement per se. It's sketchy.
I think that they're probably referring to it as a jury in a litigation, like, hypothetical sense. I mean, that's how I take it, at least.
Yeah. I think the photographer has copyright to the capture, but what he does with that capture could put him into violating somebody else's copyright. Does that make sense?
It does. Let me read what I would consider probably the home run point that they're trying to make, maybe, or the paragraph that really drives it home. They go on here. So, to put this photo on the cover of Professional Photographer magazine during Copyright Awareness Month is more than a bit ironic to us. Maybe PPA or the photographer can explain the abundance of similarities with facts and circumstances unknown to us. There's a rule that Ed likes to call Gibraltar. You don't mess with or attempt to chip away at the iconic, even a little bit. The more tidbits of visual information that are included and that look calculated to appear similar to the valuable original, the more likely the owners of the original are going to seek a lawyer to protect their economic interests. Now, honestly, I'm going to say I don't think anyone from the Norman Rockwell group is... I mean, I would think that they wouldn't bother going after us. I mean, maybe they would. But the point here, I mean, it seems more like this is an ethical thing, really. At least even from the perspective of this article. Because, they bring up this point, if something's iconic and it's well-known, you shouldn't mess with it. But, geez, I mean, I can think of a ton of stuff where, I myself, I did a Civil War album that we've talked about maybe in personal conversations, obviously. But my influence for that, obviously, looking at a lot of the Matthew Brady portraits and things like that, the influence from that came from those portraits. Now, it's not to say that I sat down and I looked at every scene. It's, hey, this is what he did in this photo, so I'm going to do the same exact thing. But I mean, we all kind of go on that line or follow that with a lot of our work. You know, I mean, all of us. I mean, I don't think all of us go out again to copy exact photos, but geez, we borrow and we emulate people, and a lot of times our creations become our own because we deviate a little bit, and we end up creating something really cool because we deviate. But the concepts and the ideas, though, I mean, every photographer does that, don't they?
Yeah, I would say so. And I don't think that you can put your Civil War stuff and Matthew Brady in the same container as this other situation, because poses are not copyrighted. And every single image that you did was just a gentleman in a casual pose. So you created in the style of Matthew Brady, but you didn't copy Matthew Brady's work. This person not only created an image in the style of Norman Rockwell, and, you know, I think that anybody that knows Norman Rockwell also, when the first time they looked at that, goes, oh, that looks like a Rockwell, because that's what I did. I had no idea there was actually a Rockwell that they copied. I think some of the burden lies on PPA Magazine, and I do think that if the Norman Rockwell Company or whoever's in charge of all that sees this magazine, I think that they have a legitimate lawsuit against the magazine for putting it on their cover, because they do make money with these subscriptions, so they are profiting off of something, you know?
Yeah, and you know what? They may well see it. I've seen this article get shared quite a few different places. All at once. I mean, I saw it yesterday morning in one place, and I ended up sharing it on my own group page, and I probably saw another 5 or 6 people share it throughout the afternoon. So I never really thought about it, honestly. You know, we've always thought about copyright, and I don't think I've ever personally gone out and tried to copy something exactly, like the exact thing, but I've definitely emulated people, and I've definitely used concepts and kind of made them my own. I think everyone does that, but I think it makes a pretty good point here about, yeah, if you take something and you totally copy it. But again, my thing, it seems like they're going after more iconic thing. You know, it seems like if it was anything else, no one would really care. But the fact that it's a Norman Rockwell painting, now suddenly there's a bigger point. But I mean, we see this all the time. I mean, talk about competition for just a minute, because you've definitely seen this in competition. I mean, you've seen people, you know, get a loan book and look through it, and I think getting a loan book and studying that and just seeing what's being put into competition is a great thing to do. But sometimes, you know, people get those and then they try to completely copy certain images or copy concepts very closely because they think, wow, if I do that, that did well. So if I do that, then I'm going to do well. You know,
yes.
on the same thing. You know,
there is a contingent of people that refer to the loan book as the clone book. So be careful with that stuff.
The clown. I've never heard that. The clown book.
The clone book.
Oh, the clone. No, I thought you said clown.
No, the clone book. But, you know, I want to point out
clown
something
is funnier.
That does support, you know, your thought that this is only protecting the famous people, because the next to the last paragraph says, avoiding any similarities to a well-known work is always a safe practice for any artist, author, photographer, or writer. They do specify well-known, and I think the reason that they say that is, I think that you should avoid copying any artist, but the well-known stuff, that's what's going to catch you. That's what's going to get you in trouble and trip you up.
But how much original work, and I mean this is an honest question, how much original work is there out there? I mean, how much is out there that's completely original and unique?
You know,
I say that in a teasing sense, but I'm saying everything has been done, hasn't it? I mean, every concept to some point has been done in some way, and I'm not saying people can't reinvent that. Absolutely. I mean, they do that all the time, but this idea that, and I've always said this, you know, all the time in anything, I feel everything's been done. Everything's been done. When you say, well, you're copying off me, and if you plagiarize word for word in a book or something, obviously that's a little bit more, that's a big issue. But, you know, you get into photography and you get into any visual medium. I mean, it's all been done, hasn't it? We're all just reinterpreting different things, right?
Yeah, I think in some manner stuff has been done, and in some genres, Oh, I guess the extent to which things are done is minimal. I mean, like right now, I'm working in some op art stuff. And there are only so many ways that you can express yourself in the op art genre. And I actually found that a piece that I put together, thinking it was all original, was very close to a Japanese artist's. And I actually got called on the carpet about it. And once I went and looked at the guy's work, and I could see the similarity. I was working with some round shapes. And there's only so many ways you can portray a round shape in op art. And it was really close to that guy's, and I felt really uncomfortable about that. So now I'm changing the way I'm doing my pieces a little bit, hoping I don't mimic somebody else.
Well, absolutely. And that, let's go back to the concept, like emulating concepts. And we talked about it a little bit, but I mean, I know you're a big Tim Kelly fan, and obviously a lot of people have studied under him. People like that teach, and pardon my ignorance if I'm not correct about this, but that teach quasi-specific lighting techniques. If you go into a class like that and you learn that and you go back and you follow it to the T, I mean, is that now? I mean, we've kind of talked about this a little bit, but is that now bordering a little bit of copyright infringement? I mean, I would obviously think no, but geez, if you shoot in black and white and you copy that to a T, I mean, obviously he's teaching it, so he doesn't have a problem with it. But anyone that does that teaches a specific concept that may be somewhat unique to their own work, you would think if they're teaching it, they're okay with it. But does that blur the line anywhere there? Is that an issue?
As far as lighting patterns go and poses, I don't think that you can copyright that stuff. There's only a certain number of lighting patterns. There's only a certain number of ways to, arrange your softboxes for a portrait. And, if somebody would accuse me, now I spent 3 days with Tim Kelly last spring and got to really know how he does his stuff as much as you can in 3 days. But if somebody ever said, you're copying Tim Kelly, number one, I would be so incredibly flattered that I finally got it the exact same way that he did. But here's the other thing. Yes, I came home and I changed up some of the way that I light. Actually, I light pretty close to the way he lights because I have all of his CDs or DVDs and learned it that way before I went to see him. And I also kind of got an old master's looking kind of background because that's what he uses. But if I would have bought the same Dave Mayhew background that he had and searched out antique shops and got the same exact antique chair that he had and had my client sit the exact same way and hold the exact same prop and basically tried to totally replicate a specific image of Tim's, that would be wrong.
Now, it would be wrong, but would it be illegal? is the more important question.
I don't know how illegal it would be, and the article that we're referring to doesn't really come right out and say that it's a copyright infringement. I think it's appealing more to us on a moral and ethical level as photographers. I don't know. Get creative and do the stuff yourself, really. If you have to go around copying people, I have to wonder about your creative level.
Yeah, it's, again, for this specific thing, Norman Rockwell, and we know some other photographers, and probably there's been many, that will look at maybe a specific artist and then want to do a series where they capture the spirit of those particular paintings, or even photographs. I mean, maybe there was an iconic photographer and they did a certain series, and in the spirit of that, you do something. It's hard to know where that line is, because I've always believed, and I've tried to do a little bit of research here just to see what I found, and I've yet to really find anything that says you mentioned, like, you can't really copyright a pose, or you can't copyright lighting, and I tend to agree with you, because there's so much overlap there that there's no possible way you can do that. But when you get down to it, isn't that essentially what every photo is? I mean, you have your light, you have your pose. That's such a big part of it. And you mentioned, if you brought in the exact chair, and like in this Rockwell shot, I mean, everything's been styled very similar, but even with that, if you look at the originals, the one that's on the PPA cover is as more of a lighter background, with more white tones and more high-key-esque, and the other one is a little bit more subdued and darker brown tones. I mean, there is the difference within that. So the question is, who makes that final decision? I guess in the case of litigation, that would be the jury or the judge, right? But lighting and posing is such a big part of any photo. I mean, it's 90, maybe 70 to 80% of any photo,
Well,
and then all the little things are what's left. So, is it the concept then? That's the question. Is who determines if the concept is a copyright? Is that what we're worried about? The concept itself, or the detailed concept?
I think there's concept involved, but look at the image we're talking about. That photographer, everything that photographer could control, they copied the Norman Rockwell. I wouldn't imagine that the photographer could control the restaurant wallpaper and the front of the counter and the color of the seats of the chairs, because for me, those are the only things that are not the same, are the permanent installations. The clothing, the props, the pose, the look, the scene, the moment was all copied. But let's go to the flip side. I'll argue both sides today. How many people have done their own version of The Girl with the Pearl Earring? Is that by Vermeer?
Oh,
Okay.
yeah,
A
a million.
million.
If you go on Google and just Google that, you'll see 1,000
Yes.
photographs of that.
So I think a lot of this uproar has to do with, number one, we're all familiar with it, and number two, we're still within the 75 years after the lifespan copyright period, registration period. I'm not up, So I think
Yes.
that's probably the big difference. Is you really have to look at when this image was created. Nobody's getting all crazy about the girl with the pearl earring, because whoever painted that is long gone, and nobody's chasing around trying to pick up royalties from his ancestors, or his descendants.
Well, you make a great point, 'cause we haven't really talked about that, and I believe copyright is the lifetime of the photographer or the artist plus 70 years. I think that's what it is, if I remember
Yeah, and
correctly.
it can be renewed
So
as well.
it can. Okay, so I didn't realize that. Okay, so I guess that makes sense. Yeah, no, that's a good point. So you look at artists from decades ago, or I mean, talking centuries ago, and you look at this. I guess that's a little bit of a different issue. I don't know. I mean, obviously we're not lawyers. I've always understood it as you can't, in a concept or an idea, you cannot copyright that. But like you said with music, there's definitely issues with that. I mean, if you've even heard things, and a few years ago, there's a few famous artists that there were issues with the choruses, and I'm trying to think of the guy's name.
Oh, the Beatles had one of
Good
those
Lord.
issues. John Lennon had an issue with My Sweet Lord, that one. That
Okay.
was actually a copy of some other artist's chorus, and actually that other artist won that particular lawsuit. Oh, let me look it up now.
Well, and that's that. No, there was the Beatles, and there was some. I'm not really too familiar with that one, but I know in the past like 10 or 15 years, I'm failing on the guy's name, but there's a few popular songs, like pop songs or dance songs or something like that, and there's a few that are played at every single wedding reception in the world. So it's playing in my head, but I know there's a few lawsuits where the intro or the chorus really close to it wasn't even a thing of lyrics. It was just the music was so close, and it was just small segments. And actually, there was another thing too. I think with recently, "Stairway to Heaven," someone took Led Zeppelin or tried to or did take them to court because they said that their original song, that intro, the famous intro that you hear in guitar centers around the world, that someone else had written it, and I heard them back to back, and they were very similar. And those you're talking, 8 bars, 8 bars of music that have been closely copied, and I don't know if that's in litigation or it's not, but it's able to get to that point. So when you look at it from that perspective, geez, if someone else wrote something as similar, 8 bars of music, and then Led Zeppelin copied that concept, and that can go to court, and people have won things like that when it's been so similar, then you have to look back at this and say, wouldn't that be the same exact thing then? I mean, if you look at it from that perspective?
I don't know. Maybe they've got some specifications for art versus music. I want to correct something. I said John Lennon. I was wrong. It was George Harrison, and the song was.
Oh yeah, okay, yeah, Sweet Lord. Yeah, when you mentioned that song, I thought
it
that was a Harrison.
I'm sorry,
thing.
but the song he copied was "He's So Fine," made popular by the Chiffons. But, maybe they do have different specifications for music as opposed to art because, you're right. A couple bars is like a mere small percentage of an entire song. And, and honestly, there are only so many notes. How many notes are there? There are 15 notes, correct? 8 majors and 7 flats, maybe 6 flats.
There's such a small library to go from, in terms of what you can musically create. I mean, you're limited to such a small amount.
So, I mean, you're bound to repeat some stuff at some point in time. And, I kind of actually feel a little bit sorry for people like George Harrison because the specific issues were 3 notes repeated, but 3 notes, I kind of feel bad for him.
It's tough. Yeah, 3 notes and something that small, or one little phrase or one little lick or whatever you want to call it. I can see how that can easily happen without doing it purposely. I think once you start getting into a 4-bar phrase or an 8-bar phrase where, and I mentioned it, and maybe we'll link this because the Led Zeppelin, I mean, you got to hear, I heard it on the radio a while ago, but you listen to these 2 phrases and they are extended phrase, and there may be 4 to 8 bars, and it's very similar. So now, I'm kind of talking myself out of where I was. I was thinking, well, it's art is art, and as long as now I'm thinking it from the music perspective, and if that's the way they view it, then I gotta say that photo absolutely is the copyright infringement. I gotta make that conclusion based on at least where the music realm goes with how that's been treated.
Yeah, I don't know. There's just, and we don't have to stay on one side. I mean, that's what we do. We bat it around, we talk about it, and I came away from a previous recording having changed my mind about something that we talked about. So there's nothing wrong with arguing both sides, I don't think.
I think it's definitely interesting, and I'm glad that the article was written because it's being passed around. People are at least talking about it. And anytime we can talk about copyright and get that out there and get people to think about that, as they work on maybe their print competition entries or just their own personal work or whatever. My conclusion is it really is, I feel, tough to create something that's completely unique. So I feel so many people have done every single concept to death. But that being said, those little tiny interpretations, how we change this subtly or change that, I mean, that's what adds spirit to something and makes it new. So I mean, we should always be striving to be okay with emulating someone, but in the end try to make it your own. Try to let it go in a different direction. And sometimes I think you can maybe surprise yourself and realize, wow, that actually is better than what I was trying to emulate or what I was trying to copy. Or not saying that you were trying to copy it, but when we let our mind kind of work its own thing, we're all different as photographers, right? So the end result should all be different. That's a great thing about this industry.
I don't think that we should be reading the law and holding ourselves to the bare minimum. I think that we have to look at personal integrity and our reputation as artists. And if we get a reputation for copying people, that's no good. And I want to bring up just a tiny little example. You had done, you referred to that Civil War album. And you did that a few years ago. And the year after that, you did a Western album. And I saw it judged somewhere. And as I was leaving the judging room, I had a fellow come up to me. And he said, if I was Ted Linzak, I would be really upset right now. And I said, well, why is that? Because I was thinking he knew that album was yours. He said, that person directly copied Ted's style and concept, but just with a different subject matter. And this guy was kind of infuriated on your behalf. And I said, well, you don't have to be upset because Ted did do that album, but it's like you have done a style. And even if somebody doesn't copy what you've done exactly, they're kind of going in a direction that you're already blazing a trail in. And it's kind of like, oh, come on, dude, think up your own stuff. But, so there's that thought.
We're allowed to copy ourselves, right?
Yes,
because that's essentially what I did. That's essentially what I did.
That's okay.
The cat's out of the bag now. The cat's out of the bag, yes. Well, lastly, before we wrap up, I think this is a pretty valid question as well. So if someone does deem that this is a copyright violation, my 2 questions are, number 1, if this is an image that did merit in PPA print comp or went loan or whatever, does that get revoked? Does that get taken away, number one? And number two, do you think that PPA comes out in the next issue or in a couple issues and addresses this at all? What do you think?
In my opinion, I totally think the merits should be stripped. I'm not even sure that this was in comp. I'm assuming that it was, but yeah, if it merited, I think the person should lose a merit. If it loaned, I think they should lose 2 merits. And I definitely think that PPA should be addressing this pretty shortly. It's serious.
I don't know where I stand on that. I feel that opens up the door. If those merits were stripped, man, it opens up the door to a lot of other things, don't you think? Do you think that doesn't go backwards and make people start looking at, wow, how closely was this copied and how close? Because there's a ton of entries that get close to that realm. I mean, do you think that opens up Pandora's box a little bit in that realm, or?
It does, but I hate to see people just skimming by with the bare minimum adherence to the rules. I hold myself to a higher standard than print comp rules. I think about the spirit of competition and whether or not I'm violating that. And I think that this is a true violation of the spirit of competition. It really is.
Interesting points. Well, that was a pretty cool discussion. A great article. I'm sure we'll link it on our blog post on the Facebook, and if you have not seen it, definitely give it a read. It's a short read, but definitely thought-provoking, and they have both photos there. So if you've not seen that photo, that is on the cover of the PPA magazine. You can see that as well as the original Rockwell piece. I think that's going to do it for us. If you guys go on the website, you can listen to all these episodes. The website is MakePhotographyGreatAgainPodcast.com. Of course, if you find us on Facebook, Make Photography Great Again Podcast, you will find links to those episodes. And I believe, correct me if I'm wrong, are we now listed on iTunes, or we're almost listed, or kind of,
we're still waiting for our final review. We have been sitting in their queue since Saturday. Hopefully any day now.
Cool. So once that's on there, you'll be able to easily use the podcast app on iTunes and be able to find that there. Also, if you are on Google Play or Stitcher, we're also listed on there. So if that's an easier method to find us, definitely check that out. You can also download the episodes online too. So if you go to the individual blog posts on our website, you can actually download those to your mobile device or tablet or whatever. So check those out. Until next week, we are signing off. So you guys stay safe and do not copy people, okay?
You have been listening to Make Photography Great Again with Christine Walsh-Newton and Ted Linzak. Come back next Tuesday for a brand new episode. For more information and access to the podcast archive, please visit our website, MakePhotographyGreatAgainPodcast.com.